Well, good morning, everybody. Thank you so very much for joining us. My name is Roland Ho. I'm the Senior Executive Director of Plan Giving. I am so very proud that we can offer these virtual stay-at-home comings for 2021, and I hope everyone is happy and safe wherever you might be, whether that might be at home, in an office, in your living room. I hope everyone is safe. And so as I said, my name is Roland Ho. I am the Senior Executive Director of Plan Giving here at UC Irvine. And in this role, as an alum, it is a great honor to be able to meet you all virtually. So I hope everyone is doing well. With that said, this workshop session is called Estate Planning for 2021. And I'm very pleased to be able to introduce our speaker a little bit later on today. With that said, let's go ahead and launch our slides for these workshop series. So let's go to the next one. Please advance. So for today's agenda, we will have an introduction. I apologize. That is the perils of working from home, is you do have family and dogs that bark and scream, so I apologize for that. So let's give it a minute or two. At least it's only virtual. For today's workshop, we will be talking about estate planning for 2021. What does that mean, especially in light of the impending tax laws? In particular, we will have an attorney from Birch, Haddock, and Roll also present to us, Blaine Birch, and he will walk us through all of the common tools and vehicles that are utilized. And then finally, we will give an overview of tax accounts and potential tax law changes for this upcoming years and some potential solutions. So let's go to the next slide, please. So a little bit about the Office of Plan Giving. Our office exists to be able to assist fellow anteaters to create a philanthropic legacy at UCI, while at the same time meeting their own personal and financial goals. In order to do this, we meet with you and we meet with our colleagues on the campus to get a better understanding of what your goals are, and then based upon your goals, suggest ways in which you could potentially leverage your philanthropic support for the university to meet those goals. So for instance, if you're dealing with a tax issue, are there ways that you can mitigate those taxes? If you're dealing with an estate tax issue, could a charitable estate gift to the university benefit you? And then finally, we will work with you and your financial and legal advisors to put in place those tools and vehicles that we may be discussing. So for today, we actually have a great pleasure of being able to work with Blaine Birch. Blaine is on our Professional Advisory Council. He is the founder and managing director of the firm Birch, Haddock, and Roll. I've worked with Blaine for a number of years in putting in place various estate plans and various complex tax vehicles as well. So with that said, I'd like to introduce Blaine to say a little bit about himself, his firm, and talk to us about our presentation. So please take it away, Blaine.
Thank you so much, Roland. I also want to thank UCI for the opportunity to be here to talk to all of you. It's been great to work with the Plan Giving Council and with UCI. Such a great institution, so many neat opportunities that they are working on for alumni and for the community at large. It's been just a wonderful opportunity and experience working with both Roland and his team and UCI. Today, we're going to be talking a little bit about estate planning. Not only just estate planning, but also some of the new proposed tax laws that are coming down the pike and how those will affect estate planning in the future. But to get kind of a good background for what estate planning means and what documents we put in place on a usual basis and what tools are out there for you, we want to kind of just go back to the beginning and start there and talk about what estate planning means and how we can move forward in that planning. So this first slide talks a little bit about what a last will and testament is. And I want to step back even further and say, most people, when they think, do I have an estate plan? If they haven't done anything, they say, no, I don't have an estate plan. Well, that's not entirely true. You do have an estate plan. It just happens to be written in the California Probate Code. So everybody has an estate plan. It's just a matter of whether you want that estate plan to be written by someone else or if you want to take control of your own estate plan. In the United States, we have free testamentary power. That means that you're allowed to give your assets to whoever you'd like to give them to. That's not true in all countries. A lot of European countries have what's called forced heirship, meaning that spouses or children have a specific portion of the assets that they have a right to. Not so in the United States. You can give your assets to whoever you'd like. So the first document we talk about is the will, and the will is the document that you take to probate or the court to help pass assets on to your beneficiaries or your heirs. Probate is simply the court's process for overseeing the transition of assets from one person to another, making sure that it's happening the way it's supposed to happen. The reason we like to avoid probate is because it's cost prohibitive, or not really prohibitive, but it's very expensive. It's time consuming, and probate also makes all of your documents, assets, pretty much your entire life, public record as part of the probate court. So we can avoid that. However, the will doesn't avoid probate. The will is the document that's created specifically for probate. There's a lot of different names you'll hear for that. There's the will and testament. There's specific types of wills, like a pour-over will, which we'll talk about later. But all of these are documents that you take to the court to go through a process of probate. If we go on to the next slide. So the next thing I want to talk about is creating a trust. So a trust is the document that we use to avoid probate, okay? The way we do that is through a contract or a private document that basically sets up who's going to control assets when you pass away, how those assets are going to be passed along, and so forth. Then the main part, or the most important part, is making sure your assets are in the trust. So you'll see here that we like to put most of your assets in the trust, especially ones that have a lot of value. That's, savings accounts, brokerage accounts, all of your real property, any business interests like LLCs or corporations, as well as anything else. However, there are some assets that we leave outside of the trust because they're handled separately. And these would normally go through probate, except for there are certain exceptions that the court allows where they don't have to go through probate. One would be like a small checking account. You can use what's called a small estate affidavit. And that means that if your estate or the assets outside of the trust are less than approximately 150,000, you don't have to take it to probate. You can sign what's called a small estate affidavit, take it to the bank, and they'll transfer the account to the appropriate person. Autos are also handled through a contract. The DMV has its own form, which basically passes the autos on without going through probate as well. And then retirement and life insurance accounts have what are called death beneficiary designations. These death beneficiary designations bypass the probate by naming who it's supposed to go to when the account holder passes away. The reason also that we don't transfer those types of accounts into the trust is because it causes income tax issues. It would be a taxable event on all qualified retirement accounts. And for life insurance can cause some issues there as well. Next slide. All right, so the revocable trust, we've talked a little bit about it. We've talked about it avoiding probate. The trust is really a contract between three people. And the three parties that are involved in any trust are a trustor, who's the creator of a trust. Second is the trustee, who manages the assets inside the trust. So they're the ones that pay the trust bills and make distributions and do the investing. And then there's obviously the beneficiary. With a revocable living trust, which is what we're talking about today, all three of those people are usually the client. The client is creating their trust. They're going to remain in control of their assets, and they're going to be the beneficiary of the trust too. However, we want to name people to step into those separate roles when something happens to the initial client. everybody has an estate. So remember, when a lot of times when we're talking about estate planning, people think, well, I don't have a lot of wealth. I don't really have an estate. An estate is just the assets that are held in your name. So if you have a bank account or anything really that you own, that's considered your estate. And anybody can create a trust. And most people should create a trust, at least a revocable living trust in California. The probate system is so time consuming and so bogged down. A trust is almost always beneficial over going through the probate process. All right, the next slide, we're going to see what an estate looks like. So again, you are the box in red, and you own all of your property. You own and manage it, and you can use it for your benefit. That's basically what an estate is. Now, on the next slide, I know that one was quick, but on the next slide, you'll see that red box of you split up into really 3 boxes. So now you're the trustor, you'll see there at the top. You're also the trustee, and that trustee is the person that manages the assets, and you're also the beneficiary. So you're receiving the benefit of the trust as well. So your property in the triangle is now held in a trust. The trustee manages those assets, and the beneficiary receives the benefit. But again, you, being the client, are usually all 3 of those people. All right, next slide. Finally, when we create revocable living trusts, and this is a common structure for a married couple, the reason we have, well, first off, we live in California, which is what's considered a community property state. Many states are not community property, and I went to law school in Virginia, and there they would not usually do a joint trust. They would separate the assets between 2 trusts, and they would do a trust for one spouse and a trust for the second spouse. Those trusts would have reciprocal provisions, basically granting everything to the other spouse if something happened to them. But in California, since we are a community property state, we can't really divide out assets from one spouse to the other. So instead, we do a joint trust, and we basically do the provisions for both trusts in one. And that's why you'll hear of an AB trust or an ABC trust. These are trusts that create what are sub-trusts at the first death to handle the estate tax exemption and transfers between spouses. So let me explain that a little bit further. We have an estate tax of 40% on all assets in your estate when you pass away. However, there is right now an estate tax exemption of $11.58 million. That means that everybody gets to pass on $11.58 million worth of assets to the next generation without there being any estate tax paid. And for a married couple, that's double because they each have that. So how do we then make sure that we take advantage of the estate tax exemption? The other issue is that number has changed drastically since I've been doing estate planning. I've been doing estate planning for about 14 years. When I started, that exemption was $600,000. It's now $11.58 million, and it's gone up and down. It even went away entirely for a year. But it's always bouncing around, and it's also one we're going to talk about later is proposed to come down drastically later on. So here we have the structure, and you'll see at the top, the black box there, that's the living trust. Okay. So while both spouses are alive, it's just one trust holding all the assets. It's just like we talked about before. The trustor, the trustee, the beneficiary are all the client. However, when the first spouse passes away, we now get to deal with a couple of different things. So we want to use, so if we have a taxable estate, we want to make sure that we use the deceased spouse's exemption. And we can't just wait to use it, maybe 10, 15 years later when the second spouse passes away. We have to use it now in the year that he passed away. So first off, we have the survivor's trust. So the survivor takes all of their assets. Remember that community property, they're going to have half the assets go into the survivor's trust automatically. So the survivor has the survivor's trust, which functions basically the same as the living trust. They can change it. They have complete control over those assets. The credit shelter trust, the box over there on the right, that is for the deceased spouse's exemption. So let's round it off and say the exemption is $10 million. $10 million of assets would go into that trust and use the deceased spouse's exemption to get those outside of the estate and not pay any estate taxes. But now let's consider that there's more still that the deceased spouse owns. So the deceased spouse owned maybe $12 million worth of assets. So $10 million we've protected with his exemption. The other $2 million are going to be put in a marital trust, which is that trust in the middle. That means that they're for the benefit of the spouse and that they qualify for the unlimited marital deduction. So there's also a deduction that says you can pass as many assets as you want to your spouse without there being any estate tax. So that's where those go. So at the first death, there won't ever be any estate tax paid because we can put as many assets as we'd like in the marital trust. So the survivor trust gets her assets. The exemption, the shelter trust uses the exemption of the deceased spouse, and the marital trust will then hold all the other assets that need to be handled without there being any estate tax. At the second death, we may have some estate tax issues. Those can be handled through further estate planning, but as far as a revocable living trust is concerned, that's as good as we can do. So at the second death, what we want to do is basically protect the kids. So instead of granting them assets outright, when I say outright, meaning writing them a check and they can basically go just put it in their bank at their own bank and they get to do what they want with it. It's oftentimes much more beneficial to give them the assets in a trust. And the reason for that is asset protection. So California has very strict asset protection rules. One of those is that me as a client, I can't put my own assets in a trust and have them be sheltered from my creditors. Otherwise, if I ever got in trouble, I would just put my assets in a trust and they wouldn't be able to get a judgment against me. However, I can put assets and gift assets to my kids and never really let them have ownership and therefore protect them from my kids' creditors. So I may want to put it in a trust for my kid and grant them powers so that they have a lot of control and can have quite a bit of access to the assets in that trust, but the creditors won't be able to attach to it. It also keeps it as separate property in case they get in a bad marriage and then a divorce. Those assets won't be part of the divorce proceeding. So there's a lot of benefit that can come from passing assets on to kids through children's trust, which is that bottom box there. All right, let's go to the next slide.
So Blaine, before we move on to the next slide, we do have a question.
Sure.
And for everybody, if you do have a question, please do put it in the live Q&A box on the bottom of the screen. But the question is, do you need, let me just read this through. Do you need a new trust document for the children's trust? And do you need 3 new documents to establish each one of these trusts? So what is the administrative function once the first spouse passes? Do you need to establish new documents? How does that work?
It's a great question, and it comes up actually quite often, right? You start talking about multiple trusts and people's eyes get big and they start to get scared about how much this is really going to cost. All of these provisions that we've talked about in the structure on the previous slide, all of the provisions for all of those trusts should be contained in the overall revocable living trust. So that means you do one document. When I do this, I do one document. It already has the provisions for the survivor's trust. It already has the provisions for the marital trust, the exemption trust, and all of the kids' sub-trusts, depending on how they want the assets to be divided out. So it's just one trust. It creates sub-trusts as it goes along, but as far as a trust agreement, it's just one document.
Another question, what if the individual does not have children? Obviously, the children's trust would be inappropriate, but I guess the question is, what if they don't have children? Can they establish other trusts? Can they make outright distributions to other individuals?
Yeah, that's a great question too. So again, remember, one of the things I said early on is you have free testamentary power. You can basically give your assets to whoever you'd like. So the fact that you don't have children is no big deal. And when I said we looked at that as a common structure, that's most people are giving assets to their kids, but you can create that type of subtrust for anybody. And often people do. Many times people want to create that type of trust for an aunt or uncle or a niece or nephew, or there's somebody that has some special needs, and so they're on benefits. So you're going to do another different type of trust for them. You can really do whatever you'd like. The structure there was just to show you how we also deal with the tax implications of estate tax exemptions.
Do you need to have a new trust drafted when your children turn 18? And the second part of this question is, what is the best age when we can make the children trustees of a living trust, successor trustees of a living trust?
So can you repeat that one more time? I didn't get the first part.
So the first part is, do you need to create a new trust when the children turn 18? And then the second part is...
Let me answer that first.
Yeah.
So the children turning 18 really does not make any difference to trust rules. Oftentimes, and my trusts include these provisions as well, we'll have provisions in the trust so that the problem is, like, a minor child can't be an owner or can't be title owner of real estate, or they can't open a bank account under their own name. There's laws against that. So we have to put provisions in that give them those assets in a trust at least until they turn 18. However, that doesn't mean you have to create a whole new document. Really, those provisions are just in your one document, just in case someone's underage. And then as far as them receiving the assets in the trust you create for them, you're creating that trust for them. So it's really up to you. If you want it to have certain provisions when they're young, and those provisions are going to change once they're 18, or maybe those provisions change when they're 30 or 40. You can add any provisions in that you'd like. And it's really important to talk to a qualified estate planning attorney for that reason, because they are going to be able to kind of talk you through that process. And it's more about your family situation than it is about the law when it comes to the provisions that you want in your subtrust for kids or for beneficiaries. And then what was the second part?
Muted. What is the best age for when you can name the children as successor trustees or a trustee of a living trust?
That's a good question. Many times I would not suggest naming a children at all as successor trustees. So let's step back. There's a couple parts to that question, right? First is successor trustee of the overall trust. That means when mom and dad die, who's going to take over and manage the administration and kind of the distribution and all of that. That's a big job. It is. Most times when I'm talking to clients, they'll say something like, well, I don't want to leave one of my kids out when it comes to naming a trustee. Believe me, you're not leaving anybody out. They got out. They escaped. The job of trustee is one with liability. It's one with a lot of work and time that has to go into it. You have to be pretty savvy with taxes and other things, because you're going to be filing tax returns and handling maybe corporate interests and LLCs and real property and distributing those. So a child may not ever have the skills or desire to take on that job. And so it's really going to be up to the individual family about, who's going to be that trustee, who's going to step into that role. We work with private fiduciaries. We work with trust companies. We work with, all sorts of other professionals that do this, if there isn't somebody that that can handle it for the family. And then when it comes to those subtrusts for kids, oftentimes we'll put in provisions that say that they can become trustee of their own trust at a certain age, meaning they can basically have control of the trust, even though it still gives them that asset protection and marriage protection and things like that. And that's really up to the family as well. I've seen that be as low as 18. I've seen it be as high as 50 or 60. So all of that is really part of the individualizing and tailoring of the trust that's going to have to happen on a client-to-client basis.
Perfect. So just as a point of clarification, Blaine, while you are alive and if you establish your own living trust, you serve as your own trustee.
You can, and most do, but it's not necessary. Yeah.
Perfect. And then once you've passed away, or once the original trustee is no longer around or incapacitated, then you name a successor trustee, which could be your children, but your advice is it's not always the best action to name younger children because of the responsibility of the successor trustee to carry out the distributions, taking care of last expenses and things like that. Correct, Blaine?
Correct. And not just younger children, depending on, if you have, my family is really, me and my sisters are really diverse. I have sisters that are into art and English and are amazing in their careers. However, they would not know the first thing to do with assets and trusts and law and that sort of stuff. So, just depending on who the kids even are, you kind of want to get into that and see if it's even something that would be in their wheelhouse of things that they can handle.
Perfect. Now, as a corollary to that original question, and we've had a couple more come in since then.
Sure.
But once a child turns 18, should they create their own trust and have their own estate plans?
I'm not sure that 18 is the trigger, but my rule is, when I talk to clients about when they should do an estate plan, my rule is, if you have a home or any real property, if you're doing rentals or anything like that, it's time to do a revocable trust. If you have kids, it's absolutely time to do a trust, or at least an estate plan to name guardians and those sorts of things for minor children. Usually somewhere in the 20s, most people are in a position where it's time to do some sort of trust.
Perfect. So 3 more quick questions, and then we can move to the next slides because I think you'll cover these. But
sure.
Are the rules, laws any different for those individuals that have only one child? What should parents do to prepare in that case if they have their only one child?
Which rules?
Rules and laws related to the creation of trust. Are there any rules that apply specifically in instances when there is only one child?
Not when it comes to creating a trust. Now, when we talked about the probate code, if you were to die what's called intestate or without any sort of estate plan, you didn't do a will, you didn't do a trust, you haven't named who you want to give your assets to, then there's some different rules about who gets what. The spouse has a portion that they get. Whether there's 1, 2, or more than 2 children depends on how will vary the amount that goes to the kids. The law is still trying to catch up with new kind of mixed families. So after, we have kids from first, second, and maybe third marriages. How do each one of those get assets, especially if there's still now a new spouse? That's on the probate code. However, all of that is thrown out the window because you have free testamentary power, meaning you can give your assets to whoever you want. So if it's 1 kid or 2 kids or 3 kids, or if you want to completely disinherit your kids, you can do that. It's entirely up to you.
You have to do that through a written trust or a will at the
or will or some document. Correct.
Perfect. I think these next 2 questions will be answered in this next slide. But those 2 questions as you're going through is, can you name 2 or 3 successor trustees, and what is the cost of hiring professional trustees?
Sure. So, and let's just step right into this slide, because that's what we're going to talk about, choosing successor trustees. And we talked a lot about this already, right? Trustee is a job. It's not a privilege. It's got a lot of liability. It's got a lot of things you got to be able to do. And all the other beneficiaries are going to be looking to you to get it done because they want their assets. They don't care that you have all these other things that you have to do first. So it can cause strain between siblings, and often does. I have a client right now who came in. We didn't do this estate plan, but their parents created a trust, put their house, their residence in the trust, named one brother, our client, as the trustee, and gave the other brother a right to occupy the house for life. And then the house would be sold, and the proceeds split evenly between them. Well, these brothers now don't like each other at all, because one has to watch over the house and the other one's living in the house, and they, one doesn't like the intrusion of the brother looking over him all the time, and the other one feels that he's not taking care of the house properly. So you basically created a situation where your kids are no longer going to talk to each other for the rest of their lives. So choosing a trustee can be a very difficult task, and it can be one that I probably spend most of my time with my clients talking about. You can have an individual be a trustee, so someone close. It can be the kids, it can be a family member, and this again is for a revocable living trust. That you can name a professional fiduciary. That is someone that just kind of comes in. They usually do that on an hourly basis. It's that hourly rate spans, but it's usually based on fair market rates for the work that they're performing. So if they're doing high level corporate work, that's one thing. If they're doing basically just administrative work, that's something else. Many private fiduciaries will also, depending on how many assets they're controlling, will take a percentage annually of the assets, usually, around 1%. Trust companies, like, there's all sorts of trust companies that are in Orange County and throughout the country. Those are more banks that also offer the services of being a trustee. And they will take a percentage as well. And that will vary based on how many assets they have control over and all of that as well. So if they're able to invest most of the assets and they're holding them in their bank, that rate can go down substantially. If it's a small amount, then the rate could be higher.
Perfect. And so just as a note on that one, these fiduciaries and trust companies do not generally take a fee until they become the successor trustee.
Correct. Yeah. So if you put them as a successor trustee in your trust, but you're still handling all your assets, you're not going to be paying them on day one. It's going to be when you pass away and they're handling the assets and doing the actual work is when the payments is going to start.
Perfect. And so the other component to that is because they are taking a fee, and once they assume the role of trustee, their fee, as you had noted, is a percentage, generally 1%, but it is on the gross amount of all of your assets, correct? So they don't necessarily take into give you a discount for any debts you might have. That's what I've at least seen in kind of industry. Are you seeing the same thing as well?
Yeah, usually the assets that they're controlling are ones that wouldn't have debt, right? They're going to be holding the brokerage accounts, the bank accounts, the real property that has debt on it. They're not usually handling that. I mean, unless they're involved in the sale or something like that, then they're taking usually they're taking a percentage of the deal, but not on like a continual basis.
Perfect. And Blaine, before we migrate too far away from the successor trustee, we did have a question. So an individual should create both a will and a trust, correct? So if you can address that just briefly.
Yeah, anytime we do an estate plan, it's not just a trust or just a will or just one document. When I do an estate plan, it's usually maybe 20 documents because we're funding and doing all sorts of stuff. But you'll do a trust, you'll do what's called a pour over will. What that will says is that if there's anything left outside of the trust, like small bank accounts or whatever, they're going to roll over into the trust. So that's why it's pour over. You'll do powers of attorney, advanced healthcare directive, assignments of property, maybe a marital property agreement. There's lots that goes into the estate plan in general. The trust is really just the main focal point that has the distributive and dispositive provisions in it.
Thank you, Blaine.
All right. I think we've talked about trustees enough. Let's go on to the next slide. So now we're talking about when or how a successor trustee can step in. All right. So there's lots of ways that this can happen. One is you're going to have, so let's say the client is the current trustee. They're going to have a couple of backups as successor trustee already named. If they're all right with the first successor trustee coming in right now and being trustee while they're still alive, they can just resign. And then the successor trustee becomes the current trustee. So that's number one there. They could also amend the trust. Remember, this is called a revocable living trust. So you can revoke it, you can amend it, you can change it in its entirety or just a little. So you can just amend it and name a new trustee. So if you no longer want to act as trustee, you can just say, I'm going to amend it. I want, my son or someone else to be the trustee. And then the other way is there will be provisions in the document that say, if they become incapacitated, then they're going to be removed and the successor trustee will step in. But usually you do have to provide some doctor's opinions on that as well. So there will always be provisions for naming a new trustee and how the trustee can step into their role. And that's going to depend on how the trust is written as well. But these are some of the more familiar ones. The bottom part there is what's called a certificate. Talks about what's called a certificate of trust. It's another document that we do, and the certification of trust is really just like a 2-3 page document that gives all the information about the trust that the bank or the recorder's office would need about the trust. So it says who the trustor is, who the trustee is, who the beneficiaries are, what the tax number for the trust is, and so forth. So you don't have to give them the entire trust document with all the provisions in it. All right. Just reading another question here. If a child is already a joint tenant, is there any need to place property in a trust? So yeah, we talked about some of these other types of assets, right? And that there's exemptions. So like joint tenant or pay on death accounts, they're fine. It's true. They will, when one joint tenant passes away, the other joint tenant becomes the sole owner, or all of the remaining joint tenants become owners pro rata of that portion. However, I would not suggest it as a good estate plan. And there's a couple reasons why. Adding a joint tenant so let's say I have a bank account that has $20,000 in it and I want it to go to my daughter. And so I put her as a joint tenant on that account. Well, she is now an owner of that account, which means that if she gets in a car accident, which, she's becoming a teenager and I'm a little afraid about her driving. If she gets in a car accident, that's now liable, to any judgments or creditors that she has. So adding joint tenants also adds liability to any asset that you have. And you can lose, everything to a creditor because of that. The other reason is what happens if that beneficiary passes away before you or passes away with you, then what happens? Many times this happens with real estate. You can do what's called a transfer on death deed. And so you'll have a beneficiary that says, well, I have a transfer on death deed. It's going to go to my, child when I pass away. They get in a plane accident or a car accident or something. They both pass away. Now you have an asset that's going to have to go through probate because it's more than the small estate, and the person that it's supposed to go to has also passed away. So now you're going to have to do probably 2 probates and you've just made a bigger mess. So joint tenancy or pay on death accounts, probably not the most effective estate planning, but to answer the question, it will pass to that owner without going through probate, as long as that owner is still, or that joint tenant is still alive when you pass away. All right. Talking about titling and beneficiaries by designation, we've talked a little bit about death beneficiary designations. And so, again, going back to retirement accounts, which is like 401ks, pensions, annuities, IRAs, anything like that that has a death beneficiary designation, we don't transfer those into the trust because it causes what's called a taxable event. So the whole reason for having a 401k is you can put money in it without it being taxed. So you take pre-tax money and put it in there and allow it to grow. So because there's more money in there, it grows faster, but you got to pay the tax when it comes out. Transferring that account from your name into the name of a revocable living trust would cause the entire account to be taxed at that point. So not a real good idea. We don't want to transfer those accounts. So instead, we deal with the death beneficiary designation. However, one of the things you can do is name your trust as the death beneficiary. Therefore, the assets still run through the trust. They'll still end up in the trust for the kids, and then will be protected. Whereas if you just name the kids, it goes directly to them. It does not end up in their separate trusts created by the trust. Okay. Life insurance is very similar. Again, it has a death beneficiary. You can name your trust as the beneficiary on these as well. One thing that most people don't understand though is insurance salesmen will often sell insurance policies as tax-free policies. That's true as far as income tax is concerned. The proceeds from an insurance policy are not income taxable. However, if they're in your estate, they are estate taxable. So a high insurance policy could cause your estate to become what's called a taxable estate, where you'd be paying taxes. It's more than the exemption that you have. That can be eliminated through the use of things like an irrevocable life insurance trust or other planning tools that we have, but you'd need to talk to your estate planner and make sure that those policies are handled properly. And then you also want to review the titling on everything, your real estate, your investment accounts, your bank accounts. Make sure that you get them in the trust, because the trust, again, is a private contract and can only control the assets that have been placed under its control. If there's assets still under your name, they're going to go through probate and they will not be handled as part of the trust. I think we skipped one. Can we go up one? Is it possible to go up one?
So Blaine, while we are getting back to the last slide, we did have two additional questions. Is it true that a revocable trust has a unique ID number, and when the trust becomes irrevocable, you need to get another ID number? How does one go about doing that?
Close. So usually when a revocable living trust is owned by the trustors, it is taxed under their own social security numbers. It does not have its own tax ID number. However, when it becomes an irrevocable trust, when the trustors have passed away, at that point, it will need its own EIN or TIN, tax identification number, and can be obtained through the IRS website, just like all tax identification numbers.
Perfect. And then the second question that we received is, I've got an estate less than 11.85 million. Do I still need a trust if my estate is smaller than that?
Only if you want to go through probate. Again, the trust, the will, if you do a will, then you're going to go through probate. And that's an expensive process as well. We didn't talk in detail about those expenses, but the court takes a percentage of all assets that pass through the court system. So if you go through probate, right now, the court takes 4% on the first 100,000, 3% on the second 100,000. And I think it's 2% up to 500,000 and 1% up to $1 million. And then it's a regressive scale going up from there. Now, That's just the court. The attorney also gets the same statutory fee. So you're paying almost 10% on the first 100,000. That's a lot of money when you can do a trust for $3,000 or $5,000 if it's a small estate. The other thing is that you are looking at the gross value. So let's say you own your home, but you have, like me, I'm young. I bought a home just a few years ago. I still have a pretty large mortgage on it. There's not a lot of equity in it. However, they're not going to look at the equity in my home. They're going to look at the fair market value of my home to make that calculation of 4%. So your estate is much larger than you probably think it is, especially your probate estate. So yes, I would say you definitely need a trust because it's going to be much more expensive to go through the probate process. So I was wrong. We have done that slide. So let's go to the next one then. And then I think, yeah, one more. So again, we've talked, we'll go back to funding. So yeah, funding the trust again is key. When I say funding the trust, that is putting the assets inside of the trust. So making sure the assets get titled into the trust. If they don't, they're going to go through the probate process. Even if you have a pour over will, you still got to go to the court and say, we're going to pour it over into the will. And they're going to take their fee, and it's still going to be a mess. It won't be as big of a mess if you die and test it, but it's still going to be a mess. And so titling, funding is something that's really, really important. It's also why you want to make sure you meet with your estate planner on a regular basis. I meet with my clients every 3 to 5 years to make sure that, have you opened new bank accounts? Do we have new real property? Have you started a new LLC? We got to make sure these are in the trust. We got to make sure that your plan is up to date, as well as, do you have new kids? Have any of the situations changed? Have the kids, are the kids have any problems? Do we need to deal with any other things? So there's a lot of planning that kind of has to happen on a regular basis. This is not like a one-time go in, get it done type of deal. Okay.
But to that point, Blaine, I'd like to add is if you have a change in your life, you should probably be updating and revisiting all of your documents anyways. Years ago, I worked with a family. I knew of a family that, there was a husband and a wife, and they got divorced, and husband remarried somebody and didn't update his estate plans, right? So years go by, he forgets to update it. He didn't have a proactive attorney like Blaine reaching out and saying, hey, what happened? And then he tragically passes away with the owed estate plan. His current wife, now widow, was not able to benefit from anything of his estate. And, because it was already in a trust and everything like that, there was a long court battle as to, well, wait, this is what so-and-so wanted. What can we do? Yeah. So I think it's always good to be proactive in terms of what should be done, in your estate plans, especially where there's life changes, acquisition of property. Along those lines, if you were to create a trust, and you name a family member as a trustee, can the family member, at their own discretion, change the terms of the trust when you pass away?
Only if you give them power to do that. So usually no. When you pass away, the trust becomes irrevocable. So the provisions of the trustee needs to carry out the provisions of the trust as they're stated. So they will be able to manage the assets, meaning they can get control of the bank accounts and those sorts of things, but they have a fiduciary duty under the law to transfer those assets to the beneficiaries in the way that the trust states. So that's where the liability comes in, right? They have that fiduciary duty, and that's a strong duty in the law. It's not something to take lightly. It's something that people go to school and get licensed in order to be able to be a fiduciary.
Perfect. And then Blaine, while you are on this slide about titling, this is somewhat related. The one question we have is, how do you handle property or bank accounts held in a foreign country?
It'll depend on the foreign law. Each country has their own, a state law, their own law on what happens when someone passes away. However, there are attorneys that specialize in American or U.S. estate planning law and how it relates to foreign countries as well. So it just depends.
Perfect.
We're down to about 10 minutes, and I think we're close. So let's go on to the next slide. We talked a little bit about powers of attorney, but any estate plan is not complete without powers of attorney. These are for incapacity planning, not death. So the two that you want to make sure that you have are what's called a general durable power of attorney that handles legal and financial decisions if you're incapacitated. So, whoever your agent is will be able to open a case in court for you, sign your tax return, do all sorts of things for you that you would be able to do in your actual name if you had the capacity to do it. You need someone that has that power. The other one is for healthcare decisions. So you want to make sure you also do an advanced healthcare directive. Two very important documents. We're not going to get into them too deep right now, but have to be part of your estate plan.
Absolutely. The one thing I would say is that if you are naming somebody in any capacity as it relates to successor trustee or power of attorney for financial affairs or healthcare, you want to talk with them, right? Let them know where it's at, because if you were to look at just the healthcare documents, right, the physician or the hospital that you might be at will want a copy of that to make sure that whoever you named actually does have that authority. If it's a financial institution, they're going to want a very, very specific document. So I highly recommend that you, one, converse with your attorney, to let the people know that you're naming them as, as their power of attorney or successor trustee, so that one, they're aware, and two, they know where your document's at, and then three, let them know what your wishes are, right? When it comes to health, well, do you want to be, on life support? In what sense, would you like to be taken off? Are you even comfortable making these decisions on my behalf, right? So these are just key questions to look at, but it's certainly very important documents to have in place.
Yeah. So we're kind of at the end of my portion. I think we have about 5 minutes to look at some of the tax code changes, and I'm going to do that with Roland. And then after that, we can take a few more questions if there's any at the end. Perfect.
So again, thank you, Blaine. A little bit about the tax code, and let's go ahead and advance to the next slide, 2 slides, one more. Let's go click 3 times for income taxes. So as it relates to income taxes, and for whatever reason, my screen is a little bit wonky. Can we bring up the full slide?
I think there's,
all right.
Yeah, who's main? There we go.
There you go. Okay, so as it relates to income taxes, right, we are under a new administration, and earlier on in the administration, then President-elect candidate Biden produced, what his plans would be for the tax plan. So right now, our income taxes are at 37%, 37% at the highest marginal tax bracket. That's at the federal rate. That said, under this proposed tax plan, it would bring back the highest income tax bracket to 39.6% for those who are earning more than $400,000 in income per year, right? Now, in this instance here, there are a number of wonderful solutions. At UCI, in the Office of Plan Giving, one of the solutions that we do look at are the types of gifts that can be made to mitigate those taxes. One way to do that, especially in 2021, is there's a special provision that allows individuals to offset 100% of their adjusted gross income by making gifts of cash to qualified charities like the university, like other charities within our community. The other component of it that we do work a lot with is just how do you appropriately avoid the taxable income in the first place, right? For our older adult friends, those who are over age 70, a great way to do that is the Charitable Ira Rollover. The other component of this is what's called a charitable gift annuity. It's a great tool, great vehicle in which in exchange for a gift, the university will provide an income stream for the duration of that annuitant's life. What's great about the annuity income stream is, one, it's fixed, it's guaranteed, but most importantly, especially in this age of a potential higher income tax bracket, part of it is also partially tax-free, right? I recently ran an illustration. The donor was getting about $20,000 in income, but was only paying maybe paying taxes on about $1,900. So that's one great way. Let's go ahead and click into the capital gains taxes. Click 3 times.
Another important part of that, Roland, is California also has a proposed tax hike up to about 17%. So that puts your total tax rate at about 55%.
Right. And that's absolutely true. So, I mean, with some careful planning, you can definitely mitigate income taxes, especially if you're interested in supporting charity. Why not leverage it to not just have that philanthropic impact within the community, but also amongst your own personal goals, right? Mitigation of income taxes. After all, Uncle Sam is the greatest tax charity in the country. If you want to support that charity, go ahead and do it. But if you want to create a personal legacy, there are ways to do that, through just careful planning. As it relates to capital gains tax bracket, again, there have been proposed changes. Right now, the highest federal capital gains rate is 20%. Under this new proposed tax plan, the highest rate would be 39.6% for those who earn over $1 million, right? There are a number of great ways to do this. Obviously, appreciated assets, the cash gifts can offset it, but if you're looking at selling an appreciated asset like real estate, charities are a great way to do that. There are also other gift vehicles as well as corporate structures that can help reduce the cost of those real estate projects. And these are the things that we work with, and it really does depend on what you're looking to do and how you want to accomplish it. Let's advance to the next page because I want to run through these real quickly so that we can have time for any remaining questions. So with regard to estate taxes, so this session obviously was all about estate taxes. Currently, the estate tax exemption, as Blaine said, is about $11.65, $11.58 million, and every dollar over that is $40 million. As Blaine was referencing earlier on, under this new proposed tax plan, the estate tax exemption gets reduced from the approximately $12 million to $3.5 million per individual, right? That's why an appropriate estate plan and an appropriate estate document is absolutely necessary. Because without it, you're paying for you're paying an estate tax that could potentially be mitigated. One of the simplest tools that we use on a very regular basis is we use charity as a beneficiary. Because just like during your lifetime where you get a charitable deduction for gifts made to charity, your estate can also name charitable entities like the university as a beneficiary. It reduces the taxable estate through an estate tax deduction. And at the same time, it creates a personal legacy for you. Now, on that note, if you do have an estate plan and you have named the university as a beneficiary, please let us know. The university has our UCI Legacy Society where we do like to honor each one of our Legacy Society members, with an annual luncheon, with invitations to special events, and further engagement in terms of opportunities that might be occurring on the university that we think you might be interested in. Anything you would like to add on that, Blaine?
Yeah, I mean, and that's, estate planning is a huge part of the law. And what we really want you to understand is there are tools out there to be used. And there are tools out there that you can use that can benefit not just you and your beneficiaries, but can also benefit UCI and other charities and can reduce your taxes and do all sorts of things for you. So more importantly than trying to understand how all of these work is to know that there's people out there that can help you.
Absolutely. And certainly at the very end, you'll have our contact information. If you need any resources, feel free to reach out to myself, to Blaine directly. We are happy to help you in any way possible, and give you any information, at least some guidance and point you in the right direction. And then finally, on the last one, the step up in basis, what we didn't talk about in this presentation is that for gifts, in your estate of like real property that you may have acquired in 1975 for $75,000, if you name that property in your trust or will to go to your son or daughter, right? Under current plan, it jumps up from the $75,000 to whatever the fair market value that property is worth. What's great about that is that your son or daughter or family member, whoever that might be, would inherit it, could sell it capital gains tax free and go away. Under the new tax plan, that goes away completely. Let's go to the last slide and we'll send out I think we're done.